whether it be personal, commercial, mortgage, or trust. We have some customers that are every single one of those pieces, and we also have title company as well. We have a couple speakers today. The first one will be Cara Blanco. She's our Chief Fiduciary Officer at American National Bank. And our second one will be Marianne Dowdy, and she's over at our title company, American National Title of Texas. Without further ado, I'm happy to introduce Cara Blanco. She is our Chief Fiduciary Officer at American National Bank. Cara?
Thank you. Good afternoon. Thank you all for coming out today. As Reagan said, my name is Cara, and I'm in the trust department over at American National Bank and Trust. And prior to that, I was an attorney in the private practice of law, practicing in the areas of estate planning and probate administration for several years. So I'm happy to bring that experience over and be with the trust department now. And as we were planning today's topic, we in the Bishop Group kind of just brainstormed common questions or issues that we've seen come up in practice, whether it be after someone passes away or you're just trying to develop your estate plan while you're living, and how to handle real property specifically and those sorts of issues that arise. So we kind of just together brainstormed a list of common questions and issues, and so for the purposes of today, we're just going to run through that list of questions and hopefully send you home with some information. So we will get started. There's Reagan. The first several questions are going to deal more with issues that come up after someone has passed away, and again, specifically with regards to real property. So if you want to go to the next slide, Reagan. The first question is, what happens to your real property after you die? And really, there's only three options that are going to control what happens to your property after you are gone. The first of those being that your property will pass according to the terms of your will. So if you have a will, it will specify who you want your property and assets to go to. The second option is that if you do not have a will, the Texas Estates Code will dictate who your beneficiaries will be, and that may or may not be who you want them to be. And we'll talk about that more in a couple of slides. And then finally, although less common, it is possible that certain property and assets may be dictated by what we call non-probate arrangements. So for example, you might have a piece of property that's subject to what we call a transfer on death deed. And on the face of that deed, it says, upon my death, this property passes to XYZ. Another common example of that would be sometimes if you have property that's held in a trust, and again, we'll talk about that a little bit more later on, but if a piece of property is in a trust, then the terms of that trust agreement may dictate who that property goes to after you've passed away. So really, those are the only things that could potentially govern what happens to your assets after you're gone. You could have a will that says what happens. You could not have a will, and Texas law will dictate what happens, or you might have one of those scenarios like a transfer on death deed that's going to specify who the beneficiary is. So moving on to the next slide. The real question here is, why is having a will important? But before we get to that question, let's just take the basic question of what exactly is a will. And as most all of you know, a will is just simply a legal document that specifies your wishes for your property after you are gone. And in terms of why having a will is important, it goes back to that first slide, that if you want to be the one in control and you want to dictate who your property passes to and on what terms, then it's very important to have a will, because otherwise Texas law may specify that for you. So moving on to the next slide, I think a common question that floats around out there is, what is probate? You hear that word after someone has passed away, and sometimes that can be a really daunting word, or maybe it has a very negative connotation of somebody has had some nightmare probate story or a probate that goes on forever and ever. And so I think there's a lot of myths and misconceptions out there about what exactly probate is. Probate is just simply the legal process of recognizing what is in fact your last will and testament after you're gone. So you've done your planning, you have this will, and then you pass away. Well, what if one beneficiary shows up with one document and says, well, this was her last will and testament, but then maybe you have another child who shows up with a different document and proclaims it to be the last will and testament. And so third parties, banks, title companies, etc., they don't really know which document is the operative document. And so what probate is just simply the legal process of having a court recognize and acknowledge this is in fact the last will and testament. This is the operative document that will pass title. So that's really all that probate is. And then moving on to the next slide, what are the steps for probate in Texas? Again, in Texas, we're fortunate in that our probate process is actually pretty streamlined and pretty straightforward, at least in many contexts. And so the steps really are, number one, that you file an application to have the will admitted to probate, and you file the original will with that. And that happens in the county where the person who passed away, whatever county they resided in, is where that gets filed. And so one quick note on that, it is the original will that gets filed. So if you have gone through the estate planning process and you've worked out all your wishes and you have your will, it is important to make sure that someone knows where you have the original. So when the time comes, someone will know where that is and it can be filed with the court. So that's step one, is just filing an application with the court. The second step is then usually just a very informal, very brief hearing in front of a judge where the judge recognizes that, yes, this document's a valid will, and the judge signs an order to say this will is admitted to probate, and typically will appoint someone who's called the executor if you have a will, and the executor is just the person who will be in charge of carrying out your wishes under the will. After that, there are a couple of additional steps that Texas law requires. There are some notices that have to be sent to the beneficiaries who are named in the will. There's a notice that will often get published in a newspaper to creditors that might be out there. And then ultimately, your executor will have to put together an inventory listing what your assets were with values as of the date of your death. Beyond that, if you have a will, and in Texas, if you have a will, it's most likely going to have a provision in there that says your probate administration can be what we call independent. And if that's the case, then beyond those couple of steps that I just mentioned, there's really no further court involvement in the process, and your executor really has the freedom to move forward and do what needs to be done to pay any expenses and then distribute the assets according to what your will says. So now, that's different than in many other states, and I may mention this again later on, but other states don't have that independent kind of probate like Texas, and so you actually have to go to court and get court approval for every single step along the way, which, as you can imagine, becomes very costly and time-consuming. But we're fortunate in Texas that if you've gone to the trouble of making a will and you've provided for that independent administration, it can really streamline the whole process. So moving on to the next slide, we're still sort of on the topic of what happens if you do not have a will. And so I just talked about the steps in a probate, the administration process if you do have a will. If you do not have a will, all of those previous steps that I mentioned still apply, but then there are extra steps that are also required if you do not have a will. And this just, again, adds to the time and cost involved. So before you can have that hearing in front of the judge, if you do not have a will, there will have to be a notice to all of the potential heirs that gets sent out to them. And then also there's usually a notice that has to get published in a newspaper to any unknown heirs that you may have had. In addition, the court will have to appoint this extra attorney called an attorney ad litem who's going to represent potential unknown heirs. And then ultimately, if you don't have a will that specifies that independent administration that I was mentioning before, you're most likely going to be stuck with what's called a dependent administration. And again, that's the type of administration where you're going to have to go to court and get approval for every single thing along the way. So yet again, if you don't have a will and your heirs are forced to go this route, it's going to be more costly and more time-consuming of a process. So that's the administrative part of what happens if you don't have a will. The next slide is what happens to your assets? Who do they go to if you do not have a will? What does Texas law say? And I apologize, this particular slide goes against every rule of PowerPoint slides by the amount of words up there, but I just wanted you to have all of that information, and I'm not going to go through all of these, but just understand there are some scenarios where if you don't have a will, depending on what your family circumstances are, your property may pass to people that you would not expect it to pass to necessarily. A common example that I saw come up regularly in practice of this would be if there's husband and wife and maybe they've been married for 20 plus years, they've accumulated substantial property together that's their community property. One of them passes away without a will, and maybe they each have children from prior relationships. Well, in that scenario, the property of the deceased spouse, his or her community half, passes to his or her descendants, not to the spouse. And so that can be pretty surprising and an unwelcome surprise to surviving spouses. Again, I saw that happen more than once when I was in practice. So just be aware that by not having a will, Texas law is going to say who those beneficiaries are, and that just is what it is. So let's move on from there and talk about, okay, so you have a will, it's been admitted to probate with the court. What exactly is the actual process of transferring title if you have real property or those sorts of assets? So number one, it is possible that the will itself is sufficient to pass legal title to your real property. So if your will is clear, and I have an example up here on this slide where it just says, maybe your will says, I give my property located at 123 Elm Street to my son, Robert. Well, that's very clear. It says, it identifies what the property is, it identifies who the beneficiary is. So really with something like that, you don't need a separate deed to transfer that title to that property. The will itself acts as the deed and transfers the title. Just one note about that is that it is still going to be subject to the administration process. So even though that will legally passes title to the beneficiary, if your estate is subject to a lot of debts or expenses, that sort of thing, the property is still going to be subject to those things. And so that may be sometimes, you may, if you've ever been part of a probate or estate administration and somebody's trying to sell a piece of property, the title company may require that they get some sort of letter that states that, you know, this estate is not still subject to administration or it's not subject to any estate taxes. And that's why that is. Now, sometimes the will itself on its face is not going to be clear enough to cleanly pass title to the property. So on the next slide, I have an example where it just says, I give my property located at 123 Elm Street to my children who survive me, which sounds straightforward enough, but if someone is just picking up the will and reading that, is it the mic?
Yeah.
Do I need to switch?
We can try that one, yeah. Here.
How about that? Can you hear me? No?
Yeah, that speaker.
Is that run off?
I'm not the one to work out technology issues.
Wind the batteries from the switch on.
Oh, that's a good idea.
The batteries.
We can still hear you without.
Can everyone hear me in the back? If I just keep talking, if they get it worked out, we'll switch back to the mic. I'll just try and speak loudly. So sometimes the will is not clear enough on its face to be able to clearly transfer title. So in my example, if it just said, I leave my property to my children who survived me, if a title company or some other third party picks up that will and reads that, they may not know who your children are who survived you. And so in instances like that where it's not completely clear from the face of the will, it's often helpful or even necessary to have a separate deed that your executor can sign. Sometimes it's called an executor's deed, to say, you know, this property is passing from the estate to these specific beneficiaries. So that kind of leads into the next question, which is, can an executor sell real property versus just distributing it out to the beneficiaries? And the answer to that question is yes, in certain scenarios. Number one, if the will specifically authorizes your executor to sell assets, then yes, your executor has the ability to do that. And that is a very common provision that you'll see in most Texas wills. It will authorize an executor to sell property. Another example would be, even if the will does not specifically authorize an executor to sell property, the beneficiaries, the distributees, can agree that the executor will have that authority. So if it's going to be easier for just one single executor to maybe sell a piece of property rather than have it go out to multiple different beneficiaries and then have them sign off, then they can agree to that as part of the probate administration. And then the final point is that under the Texas Estates Code, an executor can sell property if it's necessary to pay the expenses of the estate. So if there's funeral expenses or other expenses of the decedent that need to be paid and there's not enough liquid assets, then the Texas Estates Code authorizes the executor to sell property. So the next one is another question that I saw come up a lot in practice, and it's a common point of contention, I guess I would say, amongst beneficiaries and heirs, and that is, how do you manage ownership of undivided interests in property? So maybe your parents pass away and now all of a sudden you've inherited this piece of land, but guess what? You co-own it now with your 3 other siblings, and you may not always see eye to eye with those particular siblings, which is, again, a very common situation. And so how do you handle that? What are some ways that that can be addressed? Well, one simple option is the property could be sold, and then it's much easier to divide cash than a single piece of land. So that's always an option. Another option might be that one or more of the beneficiaries buys out the interests of the others if they don't all want to have this ongoing undivided ownership in property. Maybe they do want to continue owning it together, but just from a simplicity standpoint and just the practicality of it, it makes more sense to maybe form a partnership or an LLC or another entity amongst the siblings, so that there's one point person or one manager. You have one account to maybe bring in income, rental income for the property, again, rather than having the 4 separate owners or however many owners sign off on every single transaction. And then the final thing that could happen if you have an undivided ownership like that is that one or more of those beneficiaries could seek to partition that property. So try and subdivide that property so that everyone ends up with 100% of just a piece of it. And if they can come to an agreement about how to divide that and partition it, great. It's not always often the case in reality. And so sometimes one or more of them might bring a partition lawsuit to have that accomplished through the court, which again is not going to be a cheap proceeding, but sometimes that's the only option. On the next slide, another common thing that could happen is maybe it's not a specific piece of land that goes out to, say, 4 different children, but maybe mom or dad's will just has a provision that says, I leave all of my estate equally to my children. Well, if that's the case, then there may be ways for the executor to sort of divide that up in a non-pro rata way so that you don't end up with undivided ownership interest in a single piece of land. Maybe you have one piece of land that could go to this sibling and another piece of land that could go to another sibling. As long as they get equal value of assets, that can be another way to address that. The bottom line on that particular point is just if you anticipate that that's going to be an issue, if you own a lot of real property and maybe your kids or your other beneficiaries do not always get along so well, then try to address that on the front end while you're here to say what your wishes are. Try to address that in your will to maybe head off some of those potential problems later on. So we'll move on from there. Up until this point, I've been talking about issues that often come up after someone has passed away. Now I want to spend just a couple of minutes talking about a couple of issues that may come up as part of your planning process while you're living and as you're trying to decide how to set your property up and who you want it to pass to after you're gone. And so the first of those questions is, should you hold real property in a trust? And again, I think this is sort of a common thing that people hear, kind of like the probate term. Maybe you hear about a trust and you're not really sure exactly what that is or when you might need one. A trust, bottom line, is just simply a relationship between a person who is known as the trustee, who holds legal title to assets or property for the benefit of one or more beneficiaries who have the equitable interest in those assets. And that can be typically it's going to be a formal arrangement where you're going to have a separate trust agreement, or it may even be that the terms of the trust are within someone's will. You can see trusts created that way. And there's many different kinds of trusts and many different reasons that you might have one. And that a lot of those are way beyond the scope of what we're here to cover today. But I just wanted to touch on a common one called a living trust, also sometimes known as a revocable trust. You may hear that word or those terms tossed around. And there can be good reasons to have a living trust or a revocable trust. One of the best reasons is if you have real property that's outside of the state of Texas. So maybe you own property in Oklahoma or California or anywhere outside of Texas. The way probate works, after you've passed away, we talked about somebody will take your will, file it in the county where you lived here in Texas. If you owned property, real property, outside of Texas, the Texas probate process unfortunately does not cover that out-of-state property. And so your heirs or beneficiaries actually have to go and open a separate probate proceeding in those other states where you may own real property. And as I mentioned before, a lot of states have much more lengthy and cumbersome probate process than what we have here in Texas. So one way to get around that, if you own one or more real properties outside of Texas, is to create a revocable or a living trust while you're alive and transfer title to your out-of-state property into that trust. You're still the beneficiary of that property. You can still be the trustee of that property during your lifetime. It doesn't change how you can interact and use and benefit that property. But what it does is upon your death, you've laid out in the terms of that trust agreement, these are the people who this property passes to, and it takes it outside of the probate process, and so it does not have to go through probate in that other state where the property is located. So that can be one really good reason to look into doing a living trust or a revocable trust. You also see those kinds of trusts sometimes with incapacity planning. Maybe you own a lot of different rental properties or other real estate properties, and you actively are involved in the management of all those properties, and you have a concern about, well, what if one day I become incapacitated and all of a sudden I can't continue doing all the things that need to be done and making all the decisions about these properties? If you've created a revocable or a living trust, that can kind of be a way to seamlessly transition if you do become incapacitated, because that trust document will designate a successor to you to become the trustee. So if something happened to you, even if it was sudden and unexpected, somebody would be able to sort of seamlessly step in as the successor trustee and continue to manage those properties, hopefully without a lot of delay. And I do have on that slide, just to take a little note of, if you do have real properties that you're considering putting into a trust, whether it be a revocable trust or really any kind of trust, a few things to keep in mind there. Number one, if that property is subject to a mortgage, you need to check with the mortgage company first. You don't want to somehow trigger like a due on sale clause or something in the terms of your mortgage by transferring the ownership from your name into a trust. If you're going to be putting your house, your homestead, into a trust, you want to make sure that that trust will continue to qualify that property for the homestead exemption for property tax purposes. And then finally, just from an insurance standpoint, if you do transfer property into a trust, you're changing the title to that property, you want to be sure and let your insurance carrier know that you have done that. So one final slide that I'm going to touch on during my time here today is just another common question that comes up, and that is, if I have real property and I know I ultimately want it to pass to, say, my son, should I transfer that property today while I'm living, or should I hold on to it and pass it upon my death? And the answer to that is really, well, it depends. But some things to keep in mind. One, from a gift and estate tax consideration standpoint, and I'm not going to delve into all of the ins and outs of the gift and estate tax today, but just understand every individual has an exemption from gift and estate tax. That exemption covers any transfers that you make as gifts during your life or assets that pass upon your death. Right now in 2024, that exemption amount is $13.61 million. Every individual has that. If you're married, the two of you together, have more than $26 million of exemption before your estate would ever need to be concerned about paying gift or estate tax. So I don't know about all of you. I know, unfortunately, I'm not concerned about paying the estate tax. I wish I was. But so sometimes people might think, well, I can give away all of my property while I'm alive and not have to worry about the estate tax. Bottom line is, it doesn't really work that way, because even if you give it away during your lifetime, it still has to get filed on a gift tax return. You're using some of that $13 million exemption, whether it's during life or at death. Now, the bigger takeaway, and this is applicable to many more people, is the income tax consideration. And that is to just keep in mind, if you have real property that maybe has appreciated a lot in the time that you have owned it, you have a built-in capital gain on that property. So maybe mom has a piece of land that she bought 40 years ago for $100,000. And she's debating, should I give this to my son now, or should I wait and give it to him under my will? And maybe today that piece of property is valued at, let's say, $500,000. So it has built-in gain of $400,000, that value that it has appreciated. If she gives it away during her lifetime, son is going to have the same carryover basis that she does. So he will also have the $100,000 income tax basis. And if he sells the property, he's going to be subject to that $400,000 gain recognition. Now, alternatively, if she holds it until her death, your assets get a basis adjustment at death. So they all get adjusted to current fair market value at the time that you pass away. So if mom was to instead hold on to that piece of property until her death, it's going to get a new basis equal to the current fair market value of $500,000, which effectively wipes out that built-in gain. So son then inherits it, he turns around and sells it for $500,000. There's no taxable gain on that transaction. So that's just something to keep in mind. If you own property that has appreciated a lot in value, that's something to keep in mind if you're weighing, should I give this to someone during my lifetime, or should I sell it during my lifetime, or should I hold on to it and maybe get that basis adjustment at death? That's all that I have for the moment. I am going to turn it over to Mary Ann to talk a little bit about different types of deeds. And then we'll see if we have a few minutes at the end to open it up for any questions. Thank you.
It's still not working. Oh, this one.
Thank you. Thank you, Kara. Sure. That was a lot of great information and stuff that we at the title company deal with, on a regular basis. So my name is Mary Ann Dowdy, and I am an escrow officer at American National Title, and I'm here to go over a couple of different warranty deeds. So the warranty deed is the legal document that gets filed of record to transfer title. And there are several different types of deeds, and we're kind of going to go over the more common ones. So we've got the general warranty deed, and that provides the most protection for the buyer. The seller warrants the property is free and clear of all liens, and there are no issues against title. So in real estate closings at the title company, this is the deed that we will use, because this covers the property through the whole history of the property. We'll make sure there are no liens. Then you have a special warranty deed, which provides less protection for the buyer. The seller is not guaranteeing any issues in title that existed before they took possession of the property. So you'll usually see this when a family member is transferring title to another family member, or if somebody took title single and then they got married and they'd like to put their spouse in title, you'll usually see that special warranty deed. There's also a ladybird deed, which is also known as an enhanced life estate deed. This lets the owner maintain control of a property until their death. And then upon death, the property will automatically transfer to a beneficiary without going through the probate process. The last one is the quitclaim deed. So the seller conveys their interest with no warranties or promises regarding quality of title. If title contains any issues, the buyer has no legal recourse against the seller. So most commonly, you'll see this used between family members or during divorce proceedings. And I'm just here to give you a word of advice. Don't use quitclaim deeds. Do not use them. If you close at a title company, we won't accept them. We're going to ask you to correct that. I'm not going to say 100% of the time, but more than likely. So save yourself the trouble and do not use the quitclaim deed. There are a lot of different variables when you're transferring title. And like Kara was saying, some issues come up. There's lots of emotions. It could be tricky. So if you find yourself in that situation, we are always here to help you guys. We're here to help you go through that process. So just reach out to me or any of the officers at American National Title. Thank you.
Thank you so much, ladies. That's a lot of information to digest, I know, and some of the terminology is not common to you, so it's hard to soak it all in. But we do want to continue to be a resource for you once we leave here. So if you have questions, we're going to stay around. The American National reps and the Bishop group will stay around for a little bit. But first of all, do you have any questions for Kara?
I have a comment.
Okay.
Sometimes when we're getting ready to close something and it's in an estate, and then they're like, we're gonna either wire the funds, for the proceeds, or, give them a check, whatever. And so many people don't realize that dad or mom's checking account needs to stay open for at least a year. And so some of these people, we don't have any other way. They have to try, and then they go to the bank, and so that's one of the big things that we run against sometimes is, and I don't know how for y'all to know how to tell,
Right.
But it's just one of those weird things that they think they have to close the account, but you don't always have to close the account, at least to me, for about a year. Karen, what do you think?
No, I agree. I mean, certainly there's going to be some period of time after someone's passed away. It's probably not a good idea to just immediately close the account. And then hopefully someone during that time will get appointed as the executor or the administrator, and they might open a separate estate account. But certainly I don't think you need to be in a rush to just immediately go in and close out the account, because it's hard. You can't go back from that.
And it's strange how many don't know that. Then they'll go close it. Thinking,
Right. It's a good point.
What else do you think people that know they're going to be dealing with an estate, they're going to sell a property, they need to be prepared for, and that we need to be prepared for? I know it's kind of a broad question, but I feel like so often we get to the closing table and we're like, oh,
we didn't know this.
yeah, and things are kind of all over the place.
A lot of times there is a question on how the proceeds are to be dispersed, and the will. Correct me if I'm wrong. You have to go back to that will to see how it's supposed to be dispersed, and correct me. Go ahead.
No, I was just gonna say another thing, like an independent executor, when sometimes we do the proceeds, we have to check to the estate, and then sometimes we still get questions about how are they gonna do this or that, and we have to tell them that's your executor that takes care of that part now.
Right.
All the kids, what they're gonna get, that's out of our bounds. We just send the full check there, and then so sometimes we get some questions afterwards, not often on that, but it does come up because they don't realize they need to go to their brother that's the executer, but
Right.
whoever.
Right. This is Jean Taylor. She's with American National Title also. Thank you, Jean. I have a question.
There's a question over there.
Okay, go ahead.
I have a question. So I'm retired military, but I recently had my husband in the hospital. He was on life support. We had a lot of things to go through, and we weren't sure if he was going to survive. But when I went to access finances and the home through him, I was told through the military that I had to have a separate will through the military, as well as my will for outside of the military.
Wow.
So do I need a separate, are there separate laws for possession and deeds and the home if you are both civilian now and military?
There should not be, meaning if the property that you own is in Texas, it would be governed by a Texas will. There does not need to be a separate military will. Now, that being said, I know the military will sometimes prepare wills for people in the military, and I've seen those. And so you can have a will even if you move states. I have my Texas will. If I move to Oklahoma and I pass away and I've not done a new will, there's a good chance that they're still going to be able to use that to some extent in Oklahoma as part of their probate process. It might not have all of the terminology and things that you would like to normally see in that state's. But bottom line is a will can be used even if you've moved states. But that being said, I always tell people if you've just moved to Texas or if you're planning to move out of Texas, one of the first things you should do is go to an attorney in that state and have them look at whatever document you have and see if there's things that need to be added for the state that you've just moved to. So I'm not really sure in your particular case why they were saying that there needed to be two different wills. I don't know if maybe there were just certain provisions that maybe weren't.
His pay. So even though I was his spouse, I could not access his military government will, through the military.
That's interesting.
Access his government.
Now, the other
They
thing,
helped me. I will say I went to the law office on base, and they said, yes, you have to have a separate, will to access his pay, otherwise they won't let you. So.
well, and the other piece of that, which we haven't talked at all about today, is a power of attorney, a durable power of attorney. That's the operative document while you're living. So, if I'm living, but I go into the hospital and I become incapacitated, even temporarily, and my husband needs to do something with respect to our finances, what you want to have is a durable power of attorney that designates your spouse or whoever it may be to be your agent to handle financial decisions.
Even with our home being a VA home loan.
Yes.
My will, whatever, would still work, even though the house is under
Correct.
a home loan.
Yes.
Okay. Thank you.
Yes, sir.
I have a trust, and I guess we were talking about all the exemptions and so forth. Funeral costs, I've already paid for my funeral. I don't have any bills. I owe nobody nothing except for utilities. Well, actually, I only go for cable TV. I don't have any utilities though. So, do I need to worry about any of that with a trust?
No, I mean, there's a lot of variables that go into that. If all of your assets, if you've titled all of your assets into the name of the trust, that may be great, because when the time comes and you pass away, nobody may even have to go and file anything at the courthouse as far as a probate if you have everything inside that trust. So I usually tell people that already have a trust, there's probably no need to unwind that. If you've already titled your assets in the trust, I would leave it as is.
All my bank accounts, everything is through the trust. That's
Yeah.
why I was confused about closing it. Why wouldn't I go ahead and close it if everything's paid for? Why
Well,
wouldn't?
we were just talking about proceeds after death. I work at the title company, and so when we have to, send out the wire proceeds of the estate, we send that to the estate. That's all I was talking about. I wasn't talking about closing it, the account, the bank account. Yeah, there's no reason for you to close your bank account.
Well, as far as the trust, wouldn't I want to close it all right away and put everything in the trust? I mean, I'm confused when you say that.
She's talking about if you pass away. If you pass away and your family sells your property, the title company then has to administer funds after you're gone. So your bank accounts and all that, they have to have a trust account set up for them to send the money to.
Well, there's already a trust account. All my bank accounts are in trust, but my wife is a survivor, and we both die together. It goes to my children and grandchildren, so I'm confused on why I would want to keep a bank account open if I have no bills for that.
Because how would they get the proceeds when they go to sell
How
your
would
house?
how would your kids deposit that estate check for you and how would they deposit that if you didn't have an open account for them to put it in?
So I think what they're just saying is, if you have assets that need to be sold, like if you had a house or something that needs to be sold, your heirs or your beneficiaries are going to want to make sure that an account, like one of your trust accounts, stays open at least for the period of time for that house or property to get sold. And then you can distribute the proceeds and close the accounts after that.
Any other questions? Yes, sir.
Talk a little bit about the difference between the deed and the title. You talked about both, like they're interchangeable, and if you got the deed from the property in grandpa's name, but the will passes it down, when does the title have to transfer and how
Okay.
often in the law?
Who wants to take that? Jean, Mary Ann?
Okay, say it again. No, really, what was, okay.
What's the difference really, we talk about deeds and we talk about the title of the property, like they were interchangeable, are they? And I'm just like, can you explain those a little, what's the difference?
Well, like, Mary Ann was saying, the different types of deeds, like, we don't do quick claims and all that, the deeds that we usually use are a general warranty deed. And sometimes we have to do a special warranty deed, but they are kind of, some have more protection than others. And Kara would know better what that is.
simply says who you're gonna leave your property to, then sometimes that in itself is enough to transfer the title after death.
Okay, so what's the
Now-
difference between the title and the deed? That's what I'm saying.
Okay, so the
Okay,
deed,
title
the
and
warranty deed is like the actual document that transfers title. Yeah, it's the name of the document.
People get confused with
Yeah, I was gonna
title
say,
and deed.
yeah.
It's the same thing, like,
Yeah.
you don't get a title to your property, it's not like a car loan.
Yeah, that's what I mean,
Yeah.
Yeah.
you
They're
know,
not in a, the
Right.
title,
So you're
title
talking
is
about
more.
title, like a
Right.
different title. Okay,
Yeah.
and, but what we do, whenever we issue the warranty deed, like if you pass away and your kids come to the title company, and what we're gonna do is file a warranty deed. Like you said, it's not a piece of, it's not the title and deed is not the same thing. Cause we get, it's crazy, cause we get, phone calls, all the time about their car title. And they, cause they get a piece of paper for a car title. Well, the warranty deed is what you get whenever title's transferred.
Title is you own the property. It's who owns the property is the title. The deed is just the document or the mechanism that transfers title. And then a will can sometimes do that as well, but it's most often a deed that would be the actual document transferring title from one person to another.
so if we had property that, we had the deed and the property from grandparents that in the will passes down to the grandchildren, or to the children and the grandchildren, let's say that, and the grandparents pass and the children pass, and now the grandchildren are there, and they have the grandparents' deed and the will that passes the property to them. Do they have title of that property, even though they don't have the paper, the deed is still in, somebody else's name, you know what I mean? That's-
Yes.
Is that a critical, like on the, sign it on the hood of your car when you sell your car?
As long as they can show that that will has been admitted to probate, that it's gone through that legal process, then yes, you don't necessarily have to have a deed that says you have title to this property.
I had a scenario the other day where someone passed away and had a title to a trailer home, and the person was deceased. So they just were physically holding a title to
Yeah.
a double wide trailer,
Yeah.
but the person was passed away.
Yeah.
So,
So I have a question too, actually. We're called on as real estate agents a lot. Maybe dad passed away 5 years ago and they don't know what that basis was. So they're asking us to go back and to find the market value during that time. Can a real estate agent do that for folks, or do they have to hire an appraiser? What do you recommend?
I think it depends on what the values are that they're talking about. I mean, it's kind of a cost-benefit analysis. I mean, if they're concerned that the IRS is going to look at it at some point and it's going to become a real question, then yes, the most conservative approach would be going and getting an official appraisal. But if that's not as much of a concern, or maybe it's not as significant of a value, then it may suffice to just, have an opinion as to what the value was. Or maybe even go back and look at what the tax appraisal value was and how close they think that comes to.
Still, it's going to be different than the market value.
Right.
Another thing is I'm working with 2 clients right now on farm and ranch property. Both are estates and both have an executor with multiple siblings. They thought everybody was on the same page, but it's 500 acres, we'll just use this example, and there's 3 siblings. Well, they thought everybody would be on board to selling that property, but one of the siblings' son is throwing a wrench in it and is not wanting them to give that up. So naturally, he wants them to cut out the piece with the nice cabin on it and the entrance to the property right out of the middle of the property. And so that makes our job really hard. And then, it's just held up. They can't sell the property because they can't agree. And just because it's an executor, the executor can, if given the right in the will, correct me if this is wrong, can sell the property But when you get to closing, all of the heirs have to sign the deed transfer. So, you know, we could market and sell a property, but we could still get to closing, and if all three don't agree to sign that deed transfer.
Right. Well,
sign.
and that executor is probably going to be concerned about liability if everybody's not on board. So, yeah, that's just one of those difficult situations of undivided co-ownership where they're going to have to reach some sort of settlement agreement, or there's going to have to be a partition suit with the court.
So I know people think that's just the easy, fair way, is just to leave it undivided interest, you know, to all of your children. It's not. And especially with land, my parents, I'm so fortunate, they have painstakingly carved out who gets what land, and, you know, and made it fair and equal, and there's no question about it. Otherwise, if we didn't both agree, we would have to sell the family ranch, you know, to divide the proceeds. So it's a big deal, and that's why we want to establish relationships with you now, so that we can be a part of that planning and have the accurate information for you. Any other questions? This is all really good information. Yes, sir?
When you mentioned capital gains, does that apply to a trust too, as a will? So if I die before my wife, is that my capital gains pass to her if it's in a trust?
Well, if it's a revocable, a living trust, it gets a basis adjustment even if it's in trust, because if it's a living trust or revocable trust, the IRS kind of looks at that as you still own the property because you can revoke and change that trust. So it gets it would get a basis adjustment and wipe out some of that capital gain, yes.
Okay, when you talk about exemptions, the homestead exemption, I didn't understand what you meant by that.
Well, just with, you know, you probably get a homestead exemption on your property taxes right now. My point was just simply if you have a home, if it's your primary homestead that you're putting into a trust or that's already in a trust, you want to be sure that it continues to qualify for that exemption. Probably with it being in a revocable living trust, which I think is what you're describing that you have, it probably does. If you know, as long as that trust agreement allows you to live in it and you can live there, you know, rent free, and there's a few other things under the code, but.
We're going to hang around afterwards, so if you have further questions, we'll be glad to hang around. Do want to thank you all for coming today. It's a heavy topic. It's a lot of information, but it's so important to understand and ask questions and have the right people aligned with you so that you're prepared and leave your estate secure. So thanks again. I do want to encourage you to complete the feedback form if you will do that. And you can just leave these on your table, take your handouts, but leave the feedback form. Please complete that. We are going to have a drawing. Oh, here it is. Well, it doesn't matter.
Y'all go ahead.
All right, Jordan Barron. This is for two.
That means I can't draw myself.
Well, sure you can. 2 gift cards to the new bakery, 1889.
Marcy Avery.
Marcy Avery.
She just left.
Okay. Okay.
And then we got
One more.
Trying to.
Yeah.
Mike. I can't pronounce that last name.
Mike.
Or read it. Starts with an L.
You
guys.
It's her dad. There you go. Thank you again so much. We appreciate you all, and give us a call. We're glad to help. American National is a phenomenal resource here locally. They are a full bank, mortgage company, title company, trust department. We have such good local resources in American National, so we appreciate you all. Brad Davidson, head of mortgage division. Thank you so much. Thank you so much. The hospitality is great, and we love having this facility to do things like this. Join us for the next two, And be sure and fill out your feedback form. Thank you so much.
Sure.
And everyone, y'all can leave it on
To make him the executor, am I putting him in a compromising position?
Not necessarily. I mean, that's a very common thing that you name one or more of your children